So before that, I would like to ask to Utsav sir, like Carrie talks about turning IP into multiple revenue streams, right? From a legal and strategic standpoint, where do you see founders struggle most when they try to commercialize IP globally?
Well, so the thing here is that before you commercialize your IP anywhere, you ideally should have it registered in that country. Because see, we have now, even before patents, what is the first kind of IP that anybody gets? It's a trademark, right? So a trademark also is not filed the same way or enforced the same way in every country. Like there are two kinds of jurisdictions. There is first to file and there's first to use. So our country, India, is actually first to use jurisdiction, which means that prior user, the person or the company is using that trademark first, has priority over the person who files first. But there are many jurisdictions in the world, like say for example, I can think of Thailand and the countries in the Middle East. They are all first to file jurisdictions. So now, before you commercialize your IP, before you license it, before you make revenue from it, you need to know that your licensee will not altogether usurp your IP. And in order to do that, you need to have your IP protected in the country where you're licensing it out. So say for example, you're licensing out your IP in Kuwait. Like we help somebody file a trademark in Kuwait. So first of all, we did a trademark search. And even before we filed, from the search that we conducted for this client, it came out that almost same kind of trademark with the same name, very similar logo was already there. So before he gets to that grand vision of commercializing, he needs to know whether it's possible in that particular jurisdiction or not. Don't take it that he can't commercialize it if it's already registered, but he will need to amend his trademark, maybe make a variant of it before filing it there. So this is a practical challenge. Then of course in the online world you have a lot of counterfeiting. Counterfeiters, they use fake names, they use fake credentials and IDs. So it's very difficult to track them down. So internationally, if you're licensing your IP, that is another challenge. So yeah, that's my answer to the question.
So yeah, definitely, as everyone want to sell their products, services on e-commerce, and the duplicate products are easily available on the e-commerce, and the tracking of data is very, very hard. Sometimes it will track, we can send infringement notice to someone, but at the same time the other peoples are doing the same task. So how many infringement notice someone can send to someone doing these kind of things? So definitely this is the issue. Timestamp based data need to be tracked properly. That is another thing. So I have another question to both of you. Is there a gap today between how innovators want to use IP commercially and what the law performs realistically allow to do that? Yeah.
Sure. So see, when we talk about the gaps in law or practical implementation of say commercialization or IP, one thing that people struggle with, I think, is proper licensing, right? So I already talked about registration, that is separate. Now we come to licensing. Now, once you have your mark registered, now if you want to commercialize it, you want to make money from it, you basically give a license to a third party, and that licensee pays you a certain royalty or a fee for use of that IP. Now, what happens in this process is that it's not that straightforward. You have to negotiate the terms, irrespective of whether you're the licensor or you're the licensee. The terms have to be negotiated very carefully in the agreement, in the licensing agreement or the transfer deed. Transfer is actually different, but licensing agreement, let's say, because those terms need to be very clear that the ownership of the IP will be retained with the original owner, and the licensee will only have so much of a right to use, and there need to be very clear terms, because especially when you're talking about licensing between different countries. So if those terms are not clear, it's very easy for the licensor to eventually relinquish their own IP, right? So that is one challenge in practical implementation. And for the licensee also, they need to negotiate the terms in such a manner that they're able to effectively actually brand using that IP, whether they're running a franchisee or some other kind of branch of that licensor, that without taking over ownership of the IP, even just as a licensee, they're able to effectively actually brand and do business with that IP. So this is a challenge in practical implementation.
So I have another question to Utsav, as Utsav is handling so many cases regarding counterfeit goods. So Utsav, this is for you. So counterfeit goods on a major e-commerce platform where the focus wasn't just takedown but systemic safeguards. How did the experience change the way you view IP enforcement in digital economy?
Right, Gauri. So I think you're referring basically to a case which I was on in which basically we had filed a lawsuit against a very major e-commerce platform for allowing the sale of counterfeits of pharmaceutical products. That was this case. So I think how this impacted me is that we got a very different kind of order in this case, right? So what we got was that not only was the platform obligated to take down within 24 hours of every time that we reported the listings to them, they were also directed by the court to put in place certain safeguards, right? To put in place certain safeguards to at least identify counterfeiters or try their best, because see, in reality it's not very easy. Like I mentioned earlier, counterfeiters constantly change their names, their GST numbers, their identity. But the safeguards need to be put in place where when you are seeing a repeated counterfeit sale of a certain type of product, so at least you should have some check and balance, right? So your question being also that how this affected my outlook on how this kind of jurisprudence should evolve. So my outlook definitely in this respect has changed, that something similar to what my co-panelist has said, not very different. That it's not only about whether you are an intermediary or not, right? Like even an AI platform can contain today, like we saw Mr. Dr. Carey right now on the video, he was speaking and he was saying that the AI took his content and they basically facilitated that infringement, right? And now the AI is going to say that, oh, I am also just an intermediary, I am just a platform, and the content I just sifts through me, and I am not responsible for what's being churned out. But we cannot keep on playing that same cassette again and again. We have seen case laws in India also, where there were advertisements of prenatal sex determination on certain platforms. There was availability of pornography. So over there, the courts held very strict views even long back in the day, and they said that you need to have the right kind of measures in place. When you're profiting from this, you're heavily profiting from this, and it's happening, you cannot just turn a blind eye. And law is meant to be read in the context of the facts of each case. We can't just read section 79 of the IT Act, like my co-panelist also said, and say that it's just that you're an intermediary and you're exempted from liability. It's not a blanket, escape.
Definitely. Yes,
That's
yes.
my outlook.
Yeah, definitely. So that is a great discussion regarding this. So I have another question regarding the business asset, IP as a business asset. So you have noted that IP is no longer just a legal formality, but a business asset. From your experience, what does it actually mean to take IP seriously as a business today? Is this shift more relevant now because of AI and tech-led businesses?
So yes, definitely we are seeing the shift across the world in how seriously IP is being taken, because today with enhanced digitization, it's very easy to catch infringement online. So every brand, small or big, and we are now a brand-oriented economy, right? Everyone today is identifying brands, and So in order to take your IP seriously, first of all you need to have it registered across jurisdictions, because if you're planning on globalizing, the sooner that you register your IP across countries, across different continents, your IP will be taken seriously globally. And there is a concept of global IP recognition even before Indian courts. So there's a very famous case of Viagra before the Delhi High Court, where the Delhi High Court held that even though Viagra, there was another smaller brand called Viagra, but they upheld the rights of the well-known Viagra brand across the world, because that had a global recognition, which basically was far greater than this other brand, which was although had prior usage. So basically they went against prior usage and they upheld instead of that global recognition. So that is very important. And then also optimization of your IP, commercialization. What I have noticed is that there's less commercialization of IP in India. You could make a lot of money from your IP, royalties, licensing. But more of that happens, I see, in states like Maharashtra, Mumbai, where you have the music and the film industry. Whereas in Delhi, NCR, other prime areas of India, there's still very less licensing of IP. Even Southeast Asia, where I spent much of my life, and the Middle East I've seen, where there's a lot of IP licensing revenue. Of course, in the West, there's a lot of IP licensing revenue. So these two things. And the third, enforcement. Even enforcement is a good way of leveraging your IP. So when you send somebody a takedown notice, when if necessary, even if you file a lawsuit and you get an injunction, because injunctions are granted very quickly, at least in Delhi. So there you enhance the value of your brand, right? You're making your brand even stronger by not letting people misuse your IP. Now this doesn't mean that restrict competition, but not letting them misuse.
So in few of your interviews and few of your videos, you are talking about trademark squatting.
Yeah.
So how we can prevent the trademark squatting in the era of AI?
Right. So trademark squatting and domain name squatting, these are two things that go hand in hand. Domain name squatting is a common practice where people they apply and register a domain name without any intention of using it. Now why do they do this? They do similar things for trademarks. Whenever a genuine user will now come forward to use that particular name or something similar, this squatter will charge a handsome sum of money and make revenue from this. And the thing is that many people don't know that this is actually not legal in India and in many countries. It's not really legal because there are judgments which have held that trademark and domain name squatting is unlawful. So that definitely, we ourselves sent a legal notice to a squatter in a domain name case, and quickly there was a settlement. And if you know the law about this, if you enforce your legal rights properly, so a domain name or a trademark squatter will not be able to make unfair revenue, from the trademark or domain name that actually should be yours, because you are a genuine user, right? You actually want to use that in business.
So the last question. So in the recent newspaper article, you talked about the grant of smell mark, and you told that it should come under patents, not trademarks. So I would like to understand why you are telling that it should not come under non-conventional trademark as a smell mark. Instead of that, it can come under the patents.
Right, Gauri. So you're referring to the recent smell trademark that has been granted in India very recently to Sumitomo for rose-scented tires. So this is very interesting. This is the first of its kind in India. And here what they have said is that this is a source identifier, that people will identify our cars, our tires actually, because of the rose smell. So over here, what I have pointed out is that, and so I've given this in one business law journal, a quote, that they actually presented a diagram to the trademark registry, and they said that we have applied so and so, technical, say, formulations or, methods and chemical compounds to make this smell. So to my mind, and please anybody correct me if I'm wrong, this is just an opinion, but I think this could be classified as a patent. Because over here you have created something, right? You have created the scent through the use of compounds, and now you are trying to register it, right? So just because it's a source identifier, it can't be a trademark. In my opinion, it should be a patent. And the other thing I've said is, if it's neither of the two, then you bring about new laws to recognize unconventional and new forms of IP like personality rights, smell marks, sonic marks, and so and so.
Yeah, definitely. So if